Hello, this is Attorney Brian Pendergraft with the Pendergraft firm. And the topic of today's video is how to evict Maryland tenants if you are an out-of-state landlord that does not feel like going to Maryland. And again, my name is Brian Pendergraft of the Pendergraft firm, and I'm an attorney that is licensed to practice law in both DC and in Maryland. First, I have a quick disclaimer. This is legal information. This is not legal advice. For legal advice, contact an attorney that is licensed to practice law in your jurisdiction. If Maryland, consider contacting me, I guess. There we go. Plug myself. All right, so here's the quick presentation outline. Point number one, motion to appear electronically. That is when you motion to appear electronically via, like, let's say Zoom or a phone call. Some judges don't like it, but some will allow it. So point number two is granting limited power of attorney to a local to allow a local to come testify on your behalf. Point number three is hiring a property manager. Point number four is why attorneys cannot testify on your behalf. So a lot of times people hire an attorney and be like, hey, the attorney can just take care of everything. That's not the case. You generally can't testify. Point number five is what attorneys can do that property managers can't, i.e. practice law. You know what I mean? So you have a, let's say, a breach of lease action or a wrongful detainer action, or you file a civil claim or something like that. At that point, an attorney is needed for that, essentially. But property managers, on the other hand, they are allowed to file for failure to permit actions. Why? Because that's not considered the unauthorized practice of law in Maryland. So point number six is sending an independent employee or independent contractor on behalf of the business with an attorney. That's if the property is owned by an attorney. I mean, owned by a business, not by an attorney. But I guess attorneys can own property. You know, let me speak that into existence. Point number six is sending an employee or an independent contractor on behalf of the business. But if you're going to do that, then you're going to need to hire an attorney as well, because a business, in order for businesses to sue, they need generally the court, they're going to want to see an attorney present, at least if it's for a tenant holding over, wrongful detainer action, or a civil claim. As I stated earlier, a property manager is sufficient for a failure to permit claim. All right, so that is the outline. So you don't have to watch the rest of the presentation. I just went through everything. But that said, you should still like and subscribe so I can continue to give you guys this good content. And I have an article version available on my website at tpf.legal. All right, let's go. So motion to appear electronically. So if a motion to appear electronically is granted, then the landlord will be allowed to testify via Zoom, which is preferred because the judges want to be able to see you. Or sometimes they will allow a phone call, which is definitely not necessarily as preferred, because in their eyes, anyone can be on the phone. So if I do file a motion to appear electronically, I recommend using Zoom. So the issue with motions to appear electronically is that judges feel as if witnesses should be, some judges feel as if witnesses should be present. So I once had a judge tell me that she wasn't very happy because I filed a motion for one of my out-of-state clients to appear electronically. I showed up at court. My client was I think I chose the phone option, which made the judge even more upset. But nevertheless, she still held the trial because one of her peers granted the motion. So that motion ended up on another judge's desk and not hers. But she let me know if that motion I filed ended up in front of her desk, that she would have denied it. So for that reason, I think the best practice is to file the motion to appear electronically at the time that the complaint was filed. This way, you can get a ruling as quickly as possible. And if it's denied, then you can come up with an alternative plan in order to get that testimony in. All right, the next point, granting limited power of attorney to a local. So another tool that I like to use is a limited scope power of attorney that authorizes the local to appear on behalf of the landlord. So the local can be anyone. It can be a friend, an employee, a stranger. Of course, they will need to be familiar with the case details, but once they've been filled in, then the local will be allowed to step into your shoes and testify on your behalf. They'll just have to, bring that, limited power of attorney to court, and then have to show, oh, this is limited power of attorney, you know what I mean, authorizing my sister to step in on my behalf, whatever. So in most cases, I use a friend or a family member. However, I have had cases where my client just paid a local that they did not have a prior relationship with. Like I once had an out-of-state landlord client that needed a local to testify on their behalf. So I hit up one of my the person's basically a client, actually, or someone I have a relationship with that is an in-state landlord. I'm like, hey, you want to be given, you want to get paid? You know what I mean? This person is going to pay you to show up to court and testify, to be their local power of attorney. And they went and did it. And of course, they were landlords already. So I think I've used them as a witness before in one of their own cases. So they knew what to do. So they got paid. I got the job done for my other client. Everybody won. So again, that is the power of a limited power of attorney. Next point is why attorneys cannot testify on your behalf. So very often, someone will attempt to hire me. So someone out of state will hire me. They'll be like, hey, you know what I mean? You can just handle everything. I've hired an attorney. You can go to court. You can testify. You can take care of everything. It doesn't work like that. So an attorney the role of an attorney is very different from the role of a witness or even an agent. So most judges will not allow for attorneys to act as a witness. Our role is to make arguments from the facts that the witnesses present. Our role is not to present arguments. I wasn't there. I'm the attorney, you know what I mean? I wasn't there. I couldn't have been there, you know? But what I do, my role as an attorney is to make legal arguments, not to present facts. So if I go to court without a witness, I cannot testify 9 times out of 10. The most I can do is attempt to work out a consent agreement or ask for a continuance. Now, if the tenant does not show up for a failure to permit action, then I can ask for a default judgment. But if it's for an alternative cause of action, such as a holdover or a wrongful detainer action, then the judge will want witness testimony every time. So I'm going to need a witness there. So what attorneys can do that property managers can't? That is the next point, and that is practice law. So property managers are generally limited to filing failure to permit actions unless your property management firm works with an attorney. This is because filing failure to permit action is not considered the unauthorized practice of law. An attorney can file every cause of action, including but not limited to breach of lease claims, civil claims, holdover claims, et cetera, because even let's throw in wrongful detainer actions for squatters. Because why is that? Because we are authorized to practice law. And my next point is sending an employee or an independent contract to testify on behalf of the business. Now, this is if the property is owned or managed by, let's say, an LLC, for example. So you can send, at least to act as a witness, you can send an employee. But say if you're filing a failure to permit action, and perhaps an employee can perhaps show up by themselves, essentially, you know what I mean? Because or maybe you can use a property manager or something. In fact, you know, they can just say that the property manager on behalf of the business. If it's just failure to permit action, it's fine. But if it's anything other than a failure to permit action, such as a wrongful detainer action or a breach of lease action, all that stuff that I just said in the last slide, at that point, you would need to send both the witness, the employee, the witness, and you would also need to send an attorney. And the reason why the attorney needs to be there is because, again, it will be the unauthorized practice of law without the attorney. So in other words, an out-of-state business, you can send both an employee who's in-state or maybe even an independent contractor on behalf of the business. You can do that as well. And you would also need an attorney to be there as well. And let's see, is that it? Yeah, let's see. Let me check the slides. See if there's any points that I missed. So one of my clients is a bank. Yeah, the court does not expect for the owner of the bank to show up. An employee or independent contractor can get the job done. And yeah, that is it, man. That is it. I think that covers everything. So we are done here. So if you have any questions that you would like considered for the Ask Attorney P series, you can let me know at tpf.legal/ask. And thanks for watching again. My name is Brian Pendergraft of the Pendergraft firm. If you haven't subscribed, make sure you click the subscribe button, ring the bell, subscribe or die. Alrighty, thanks for watching.